Hi, I'm Mitch Tanenbaum. Today I'm going to talk about state privacy laws, and in particular, I'm going to talk about the Colorado privacy law. That's the most recent state privacy law that has been passed. I'm going to go share my screen real quick and show you a few things, and then I'm going to talk about it. So the Colorado law is Senate Bill 21-190, if you want to look it up. It applies to legal entities that do business in Colorado and target Colorado consumers. It does not have a revenue minimum. What it does instead is say, how many records of a Colorado consumer do you collect per year? So if you collect 100,000 records, which to me, that's a big company, or if you sell records on 25,000 consumers a year, then you're covered. If you're below that threshold, then it doesn't matter whether you make $1 bazillion or not, you're still not covered by the law. It also doesn't cover state and local governments, colleges, and it also does not cover information that is publicly available. So the other thing it does is it talks about two categories of people that the law affects. One is a data controller. That's the person or company that collects the data and then controls what happens to it. And then the other category is a data processor. That would be a service provider. So if you had somebody who was fulfilling a mailing list for you, let's say you're emailing 100,000 people, and you hire a mailing service to go do that, they would be a data processor. Those terms were taken from the European law, GDPR, and those two groups of people have different responsibilities. There's a lot of information here. I'm not going to read this, but what I am going to do is talk about a couple of things here. So first of all, you have to get specific permission from the user to go collect their data, and that you can only use it for the things that you specifically said. So, for example, if you're selling T-shirts and you need someone's address to go sell a T-shirt, then you can go ask them for their address, but you don't necessarily need their birth date unless it's an adult T-shirt, and I guess in which case you could ask for it, otherwise you can't ask for it. The other thing you can't do is you can't go off and collect the information to sell them a T-shirt and then use it because you want to market something else, or you want to use it for some other purpose. So specifically for that, you can only collect the minimum amount of information you need. The other thing that the law does is allows people to opt out of targeted advertising, which of course the advertisers hate, because targeted advertising is how they make a lot more money. If you go look at people like Facebook, they make, I don't know what the exact number is, 10 times as much money from a targeted ad than they do from a blind ad. So the other thing you'll be able to do here as a consumer is that you will be able to opt out globally. You won't have to go to each website, find where they put the stupid thing, and say, I want to opt out from this website. You'll be able to do it from all websites. The other thing it's going to go off and do is it addresses dark marketing, I think it's called, basically where they make it very hard for you to figure out how to opt out. That does not work. So those are things you can't do. So with that, let me just talk about a couple other things. The states are passing these laws because consumers are concerned about what's going on, what's happening with their data, and the feds are not doing anything. I guess it's possible the feds might do something. I'm not counting on that, but it's certainly possible. And if they do, then the question becomes, will the state laws be overridden by the federal law? That's also possible. Businesses, of course, are concerned that there's more compliance responsibility and more challenges for them in terms of what they can and can't do. And businesses historically have been able to do anything they want with data that they've collected. Now, all of a sudden, these state laws are putting restrictions in there, and that's upsets some companies. So let's see what else here. You can prepare now. The Colorado law does not go into effect until 2023. The Virginia law also goes into effect in 2023. The new California law goes into effect in a few days in 2022. So you could go off and wait and see whether the legislature changes it, or you could start figuring out how you're going to become in compliance with it. I'd recommend doing that. The legislature attempted to find a balance here in Colorado and also in Virginia. In California, people have what's called a private right of action. They're allowed to sue if there's a breach. In Colorado and Virginia, you can't do that. That's kind of a balancing thing. So, whether small companies, big companies, how you define that threshold, who's included, who's not included, those are all things that the legislatures are wrestling with. And obviously, a state could potentially be put at a disadvantage if, someone is in a different state and they don't have to comply with it. Well, the answer is they do have to comply with it because it's based on where your customers live and not based on where you're based. So you could be in New York, but if you're selling to people in Colorado, then you have to comply with the Colorado law or the Virginia law or the California law. That's part of the problem why businesses don't like that. Another thing that's a concern for businesses is, well, exactly what data do I need to share? If I say that I share it with my marketing company, do I need to say who the marketing company is? I think that's still an unknown. The Colorado Attorney General, Phil Weiser, is required by this law to create a set of rules and regulations. Hopefully those regulations will clarify some of these questions that people have. But right now he hasn't done that. He will do that in 2022. And once he does that, then I think we'll have a little bit more clarity. But how much data that I might consider sensitive to competitors do I have to give out to consumers? Unclear. You have a duty to avoid secondary use under the Colorado law. That means if I go off and collect this for selling you T-shirts and mailing you a T-shirt, I can't go off and use this for marketing something else, or I can't use it for a completely unrelated purpose. And the law is fairly restrictive, and I think that's done on purpose. The issue is it's reasonably necessary or compatible. The other thing that I think that's important that you got to understand is that you're going to need to track what the data you collected from whom and what purpose you said, so that you can know whether or not that particular bit of data can be used for some other purpose. So you can't glom that all in a database and said, I have 6 different sources of data. I buy a list from this person. I buy product registration cards from this other company. This data I collected on my website. A consumer went off and filed a request for a product, and I collected data there, and all of that. Each one of those probably is going to have a different purpose restriction. So you're going to need to go off and track what you told people and how they're going to use it. So we will find out in 2022 more information about this. It'll become clearer, and I also anticipate that more legislatures will implement laws in 2022. But right now is a good time to go off and start figuring out what you're going to do and how you're going to comply and whether you have to comply. You could potentially have not been required to comply in California because of the revenue rule, but in Colorado, because there is no revenue rule, you may collect enough records that you have to comply under the Colorado law. So all that is important to understand. Obviously, if you have questions, please reach out to us. And thank you for listening.